Now, as you may know, the National Assembly has been debating a bill to set up ranches across the country aiming to confine roving herders into controlled grazing areas to prevent them from encroaching onto farms as they search for pasture and water. And it's not just farms. Herders have often been seen on modern motorways with cars and cattle competing for the right of way. Hence the idea of ranches or cattle colonies currently being mooted in the Senate. But even in Parliament there is deep suspicion, with some politicians framing the debate as an ethnic, regional and religious issue, keeping in mind that the herders are mainly northern Fulani Muslims, while the farmers are mostly Christians from central and southern Nigeria. But now some of Nigeria's most experienced constitutional lawyers are weighing in on the debate, arguing that the National Assembly does not have the power to enact legislation establishing ranches. They say that neither ranching nor animal husbandry is provided for under the exclusive legislative list and therefore cannot be accommodated under the Constitution. Well, one of those who's propounded the legal arguments that the National Assembly does not have the power under the 1999 Constitution to enact legislation establishing ranches is the constitutional lawyer and senior advocate of Nigeria, Chief Sebastian. And he joins me now in the studio. Thank you very much indeed for coming in.
Thank you, Charles.
So your argument is that the National Assembly is not constitutionally empowered to enact legislation establishing ranches in Nigeria. Tell us why.
Absolutely. They don't have the constitutional powers because the legislative powers of the National Assembly are defined in section 4, 1 to 3, sub 1 to 3 of the Constitution. But however, those powers are limited by the list of items enumerated in the first schedule, which is the exclusive list, and the concurrent list. Unfortunately, the bill does not pass the acid test of legislative competence of the National Assembly because the only item, throughout the exclusive list, there's no authorization for that bill to the best of my knowledge. And then, naturally, one would fall on the concurrent list. Under the concurrent list, the only item that may have assisted the National Assembly is item 17D
right,
of the Constitution. But that item limits the power of the National Assembly and a State House of Assembly to enacting for financing and promotion of agriculture, not for establishment of ranches or for acquisition of land or for any of the other things stated in the bill.
Right.
Now, if you also look at item 18 of that schedule, the concurrent list, you will see that such a power is vested exclusively in the State Houses of Assembly. So, to that extent, the National Assembly has no legislative power to legislate on that. In fact, in the absence of item 18, the matter will still have fallen under the residual powers of the State Houses of Assembly, because legislative power to enact a law is not broad or unlimited. It is circumscribed by the items listed in the schedules. Unfortunately, none of the items considered in that bill falls under either the exclusive list or the concurrent list.
Well, you're the constitutional lawyer, but let's, from a layman's perspective, who is observing what is going on, let's take it one after the other. You mentioned the word promotion,
yes,
which does appear in the list of things that the National Assembly can do.
Yes.
The word promotion literally means an activity that supports or encourages a cause, a venture, or an aim, something that advances a cause or acts as a catalyst. Don't you think that is what it means when it says that the National Assembly may make laws with respect to the promotion of agricultural projects of which ranching is one?
Well, even from your definition, with due respect to you, that definition does not cover undertaking. It covers rendering some form of support, not undertaking to do. Because promotion has the literal meaning attached to it, even under the ordinary dictionary. In any case, if the framers of the Constitution had intended that the interpretation be stretched beyond the literal meaning of the word promotion, then Article 18 wouldn't have come in, which vests exclusive powers in the state houses of assembly to undertake development of agriculture. So, you see, and under rules of interpretation of the Constitution, a later provision overrides the former. Even supposing for the sake of argument, or supposing I'm to accept with you, that the word promotion in item 17D will now give way to the word management or development of agriculture.
Wait, they're not planning to manage. They're simply enacting a law that is going to allow things like a commission, for example, to come into existence. And that commission's job is to promote the idea of the whole concept of ranching with all the issues and the powers and everything that goes with it.
Oh, you see, but the National Assembly didn't say they are going to manage. They are going to enact a law that will enable management.
Yes.
That is the crux of the matter. And I'm saying they don't have the power. Their legislative powers are limited to enacting the law that will enable promotion and financing.
So is your challenge to the bill the way that it is presently written? In other words, in its present form? Or is your challenge more fundamental than that?
It's a combination of the two. And let me explain further. Now, you see, when you come to interpretation of legislative powers of the various legislative houses, strict interpretative jurisdiction is exercised by the Supreme Court. And I will give you a few examples. In 2003, Gani Fawehinmi took Ibrahim Babangida to court concerning the setting up of the Oputa panel. Now, under that law, the panel operated because the 1966 Act had given it power, the National Assembly power, to enact law on evidence. Now, the Act now, pursuant to that constitutional authorization, empower the Commission of Inquiry or a panel of inquiry to summon witnesses or compel their attendance. You can see how close these are. But the Supreme Court said, no, the mere fact that you are giving powers to enact a law on evidence shouldn't be interpreted to include compelling of evidence. So, in 2003 again, Lagos State government took the Federal Attorney General to court. And what was the issue? If you look at, I think, item 58 of the exclusive lists, it talks of tourist attraction or managing tourism. And then the federal authorities were challenging Lagos State government for enacting the law on hotel management, on restaurants, on kiosks, on eateries. See how close these items are. Supreme Court said no. National Assembly, you don't have power. You are limited to tourism. You don't have power to enact a law on tourism, on hotels, restaurants, kiosks, or eateries. That is for the residual list.
Right.
Now, beyond that, beyond the constitutional enablements, we have ECOWAS protocol and regulations on transhumance. Transhumance simply means movement of livestock from one location to the other. Now, this was enacted or agreed upon in 2003. Regulation 0301-203. Until today, Nigeria has not taken any step to give effect to that international treaty or regulation. So nothing has been done in terms of preparing routes, because there are supposed to be special routes. And in every given situation, herdsmen are not supposed to move cross-border with more than 300 cattle, all in all. And stakeholders are also supposed to be involved. A monitoring team is supposed to be set up, and a lot of things. And if you look at the bill proposed by the Senate, they have mentioned transhumans in section 6G of that bill, without complying with that. Now, that is one angle in the sub-regional setup. In the regional setup, the African Charter on People's and Human on People's Rights, which has been domesticated as a law of the Federation 2004. In section 1, there's a mandatory provision that before the National Assembly or the executive or the judiciary does anything, they must bear in mind the provisions of the Act. And what are the provisions of the Act?
Briefly, because we've got to move on from
Very
that.
well so.
Yeah.
Provisions of the Act include respect for the human dignity of other people, respect for the food sources of other people, respect for the security of other people. Now, but we have seen that these things were not factored in that bill.
Right. So your argument basically is that in its present form, which is the question I asked you earlier, it's not properly presented, and that what I'm wondering is whether your challenge goes just beyond, because if they rewrote it, would that, maybe conforming to the things that you're talking about, would that allow it to still to go through the Senate?
Yes, of course. If they rewrite it
Right.
to comply, first of all, with the Constitution, and then to also comply with the ECOWAS regulations.
Right.
And then also to comply with the Land Use Act. One thing I missed, because the Land Use Act is an existing law.
Yes, so that was raised in the Senate as
Very well.
Yeah, by one of the, I think it was Senator Baribe,
Yes.
raised that on the floor of the Senate.
The African Charter on People's Rights Ratification Act. Then it will pass. But the fundamental 99% or more of that bill will go.
Right.
So rewriting, in this case, means total overhaul.
Right. Okay. Well, obviously, it's out there now in the public are getting a chance to discuss that document. You've written a 36-page opinion on that ranching bill, and I've read it. I mean, I think it's a very good, very well-written piece of analysis.
Thank you.
But is it likely, in your assessment, that the Senate will hearken to the things that you're saying, or will it continue with progress on this bill in spite of the challenges of people like you, and that it might actually end up becoming law? Because some people have made that argument.
Well, it's left for the Senate. In the first place, I think that public hearing enables constituents and Nigerians to come up to assess critically any bill. And it is not just organized for the sake of it being organized. It's organized because they want to measure the tempo, the public tempo.
Yeah. But also make sure they got it right.
Very well. Because any lawmaking process that is not for the good of the people of Nigeria is not a good process.
Well, I mean, would you be attending that public hearing?
For sure, I will be attending.
Right. Because the reason I say that is that if it ends up in court, where it is likely to end up with people like you obviously disputing it in its present form, I mean, assuming it passes, I mean, is it possible that the courts might interpret it differently from you, for instance? Might they emphasize the part of the Constitution that gives the National Assembly to make laws that establish institutions?
Well, because you see, the legislative powers of the National Assembly, as I told you, are circumscribed by the items listed
Right.
in the lists. So institutions to be established must also conform to the items
Conform.
listed. Yes, conform to the items listed in the schedules. So it's
But
not
potentially
obliged.
it can be made to conform.
Yes, it can be made to conform. It's
Right.
not too late. And let me give you one instance. In 2003, there was this matter, Attorney of Abia State against Attorney of the Federation, where the Supreme Court had to pronounce on a similar thing you are asking. Supreme Court said the legislative powers of the National Assembly are not to enable them make any law to cover anything or all things. Just for the sake of good governance, peace, and security, that they are limited to the lists or the listed items in the first and second schedules. So, the power to establish institutions is not at large. For instance, we have two basic constitutional doctrines under federalism, and the two are intertwined. The first is the doctrine of mutual non-interference, and there is also related to the doctrine of implied prohibition. You are impliedly prohibited from encroaching on state power.
Yes.
And you are also prohibited from interfering in state power. And that is vice versa, pari passu. So state powers at the state level, the state assemblies too don't have power to interfere with what falls under the exclusive jurisdiction of the National Assembly. So we're talking of a federal setup that has rules. It's not that you just set up a commission, the commission goes into a state, and if you look at section 6 of that bill, it says the commission has power to determine the number of ranches in a state. The commission has power to run those ranches through branch controllers without recourse to the governor of the state. When all lands vested in the state are in the hands of a state governor. So these are the issues. They are very fundamental.
But what if I think you're making a very, very interesting and very powerful argument there. But what if the National Assembly, in collaboration with the federal government, which they're probably doing at the moment, decides that there ought to be a national law on the issue of ranching, which brings the whole concept under one unified legislation, rather than having different states enacting different legislations, as a way of solving a national problem, which is the deadly intercommunal conflict between herders and farmers in this country. The reason I say that is that I'm wondering, you have more experience about these things than I do, but I'm wondering whether the Supreme Court, for instance, may well take into account the wider socioeconomic and security issues which make it necessary to enact a law in relation to ranching in Nigeria, notably the conflict between herders and farmers.
Now, it's a good question, no doubt about that. Now, why is the bill one-sided? The security of the farmers not mentioned, and then movement, cross-border movement of herdsmen to be regulated under the ECOWAS transhumance protocols and regulations, not taken into account. Now, it is easy, in my own opinion, for the National Assembly to enact a law on security. And if it is security, it should be all-embracing. The provisions should leave no one in doubt that maybe one set of people are being preferred. That it's security for everybody. in which case they will have legislative competence.
Right.
Because on matters of security, the National Assembly has exclusive powers. Yes. So, but they have not done that. In fact, throughout that bill, you will never see security.
Right.
But
I
no
guess,
mention of security.
as you said, that's why it's out to a public hearing.
Very well.
And hopefully they'll take into account the very sound analysis that you've done and the suggestions that you're making. But obviously, given that, and I want to tap your sort of considerable experience here, given that a national approach to the issue of farmer-herder conflict, which, as you said, involves security, a national approach through a law would probably be preferred. Wouldn't it be better to find a way to carry everyone along rather than state that governments sort of doing their own thing and so on?
Yes, it is twofold. Now, for ranching in particular, the National Assembly has no power to establish a law regulating ranching. It is a residual power of the states. But for security, they have power. They have the powers.
Right.
Under the Constitution to do that. Now, there's a way legislative maneuver could be done to achieve the desired effect.
Right.
Without infringing on constitutional provisions.
Right. Because the Constitution must always be sacrosanct.
Respected. So, but from the way they have come, there's total infringement, total incursion into the legislative powers of the states, and total lack of legislative power.
Right.
On the side of the National
Well,
Assembly.
I think it's very important for you to attend that public hearing. And for, I mean, it's not just you. There was, I think, a retired Supreme Court justice as well, and a few others who've kind of made your points and supported the points that you're making. But I'm curious that you are from Benue State. Is that right?
Yes, I am.
And I mean, Benue State is one state that has greatly suffered from herder-farmer clashes. So it would be in the interest of your state for this ranching bill to be unified and passed, wouldn't it?
Yes, of course. I am not against it. Honestly, I just want the best thing to be done. Otherwise, as the common saying goes, we'll be moving from pan to fire. We have an anti-open grazing law enacted by the past governor. It is still there, and it is competent. It was competently enacted by the State House of Assembly. It was being enforced by that governor. So we don't need any supervening bill from the National Assembly. Each state has power to regulate what happens in terms of ranching and related issues. Ondo State passed, some other few states passed. So it's not within the powers of the National Assembly to go and pass. And in any case, you have read my 36-page document, which I don't know how you got it, but we thank God you got it. Now, the truth is that the Supreme Court has consistently held that you cannot use your National Assembly legislative powers under the doctrine of covering the field.
Right.
When you don't have legislative powers to do that.
Well, obviously, the reason they got interested in this was because of security.
It is not stated in the bill.
So if it is modified to incorporate that, then I'm sure it is something that you would probably also support.
Yes, but
like
they will eliminate more than 90% or 95% of the contents of the bill.
Well, I'd be very happy to get your assessment after you've gone and spoken at that public hearing.
I will do so by God's grace.
But I want to thank you very much indeed for coming in, and also congratulate you on that very, very interesting opinion document. It was rather difficult to plod through it because it was 36 pages long, but I mean, I thought it was very well done. So thank you for coming in and sharing this with us, and I hope the people who are dealing with this ranching bill are listening to you and will listen when you attend that public hearing. And Chief Sebastian Hon is a constitutional lawyer and senior advocate of Nigeria. Thank you very much indeed.
Thank you.